Justice Kagan?
I'm wondering, Mr. Francisco, whether your answer to Justice Alito didn't contradict, or at least is in tension with your answer to me, because when I talked to you about some of the dangers that taking off these expenditure limits would have, you said, no worries, because really everybody's just going to continue to contribute to super PACs. That's really the way to favor a candidate. But to Justice Alito, you said, no, this is going to reshape the balance between super PACs and parties. And I'm inclined to say that you can't have it both ways.
So, Your Honor, I think that what I was getting at in response to your question, and if I wasn't clear, maybe I can clarify it now, is that there's not the risk that somebody is going to try to launder a bribe through the party to the candidate in exchange for official action, particularly when that so-called bribe is capped out at $44,000.
Which it's really not $44,000.
When they can call it $500,000, call it whatever you want through this very
$500,000, that's a lot more than $44,000.
Through this very circuitous joint fundraising operation that has never occurred in the quid pro quo context.
Yeah, nobody seems to find this circuity all that difficult to deal with. At this point, all of these committees are in constant communication with each other and funnel money back and forth without any difficulty. Because of, once you have the joint fundraising committees in place, this is not very difficult.
And then you would think that if it were so easy and it were so common, it would be fairly easy to find at least one example in all American history to find where it has been used to effectuate this type of quid pro quo conduit bribery. Yet there is none, not in that context, not in any other context, even though there are lots of laws that will allow that type of scheme if you wanted it. But let
me ask you another question, which is, on your theory, as I understood your theory, if you took everything that you said to me about why we shouldn't worry about, and to the Chief Justice about why we shouldn't worry about these limits, I would think that that would apply just as well if it was another kind of group rather than a party that was coordinating with the candidate, or indeed if it was an individual coordinating with the candidate. Why wouldn't everything you say apply to individuals and private groups?
Sure.
Such that now, rather than telling those individuals you can go contribute to a super PAC or do your own independent expenditures, but no, you cannot coordinate with the candidate for more than $3,300. Now you can.
And it's all of the reasons that this court gave in McCutcheon why this type of conduit bribery scheme is less of a risk than a direct bribery scheme.
No, I understand that that's your argument. And what I'm asking you is that that argument applies just as well if instead of a party we substitute another group or an individual.
Oh, I very much disagree with that, Your Honor. If I'm an individual and I want to directly bribe a candidate, I can say to the candidate, I will either give you $50,000 cash, $50,000 donation, or spend $50,000 on your behalf. I am directly bribing that candidate with whatever benefit I'm offering. With conduit bribery scheme, you by definition don't have that direct relationship between the donor and the candidate.
Yeah, boy,
Instead,
you are assuming a lot there about people's honestly dumbness. I mean, everybody knows where the money is coming from when it's done this way. So the fact that I have a party as a conduit, the fact that I have a different private group as a conduit, it's not hard to figure out where the money is coming from, either for that person, the original source of the money, or for the candidate. And all I'm suggesting to you is that if your argument sort of depends on, in fact, this is very complicated, people don't do this, you have to devise a flow chart to see how it works. I can be skeptical of that, but even if I put that skepticism aside, it would apply just as well to a conduit that was not a political party, to a conduit that was another private group, or indeed to, an individual.
So 2 responses to that, Your Honor. The first is that I think I'm simply assuming, whether it's dumb or not dumb, I'm simply assuming the same chain of reasoning that this court adopted in McCutcheon when it explained that the risk of conduit bribery was not nearly as significant when you had the party standing in between.
See, I don't agree with that. I
candidate.
think that McCutcheon says, I was on the other side of McCutcheon, but McCutcheon says we take these circumvention rationales seriously. Now, they said there was no reason to fear circumvention there, but the entire thrust of the opinion was if you could show us that this was a way to circumvent the base limits, that would be a reason to keep these limits in place. And then, in evaluating why the aggregate limits were not necessary in order to further anti-circumvention goals, the court specifically pointed to this limit as part of the status quo that would prevent circumvention.
So, Your Honor, maybe we just have different readings of McCutcheon, but I'm relying on the statement, for example, where McCutcheon said there is not the same risk of quid pro quo corruption or its appearance when money flows through independent actors to a candidate as when a donor contributes to a candidate directly because, the court explained, when an individual contributes to a party committee, the individual must by law cede control of the funds. And then the court went on to cite the Assistant Attorney General's testimony about how there should be, quote, fewer cases of conduit contributions directly to parties because donors who wish to influence elections or officials will no longer need to attempt to do so through conduit contribution schemes that can be criminally prosecuted. Instead, they are likely to simply make unlimited contributions to super PACs. So that's the portion of McCutcheon I'm relying on. I actually think that, I fully understand and appreciate the concerns that you're raising, but I don't think that they're tied to quid pro quo corruption. I think they're tied to a broader understanding of a corruption that was adopted by the McCutcheon dissenters, where it wasn't simply limited to quid pro quo corruption, but rather the corrupting influence that many believe that money can have in politics.
You have assumed that that ship has sailed. All of my questions to you have assumed that what we're doing is preventing quid pro quo corruption, and the portions of McCutcheon that I could cite back to you are the portions that make it quite clear that if there's a limit that is necessary to prevent circumvention of the base contribution limits, that is a reason to have that limit.
Well, respectfully, I think McCutcheon would have come out the exact opposite way in that case, because that was the whole point of the aggregate
I think that
limits.
the point of McCutcheon was that they didn't need, in those particular circumstances, with respect to aggregate limits, that there wasn't a circumvention problem. But that is not to say that in these particular different circumstances, with these limits, which indeed McCutcheon specifically pointed to, that there's also not a circumvention problem. There is, because of this thing that we started off with the fact that coordinated contributions, you might as well just be giving money to the candidate.
McCutcheon pointed to Colorado 2, I think, once when it was batting down the barrage of hypotheticals that were asserted by the dissent in that case. But I think that the thrust of the reasoning of McCutcheon is that if you have an implausible theory and zero evidence to back it up, that's generally not going to be a strong First Amendment case. Here you've got the same implausible theory that you had in McCutcheon, the kind of conduit bribery scheme, and they've got zero evidence to back it up. I simply don't see how you can hold up Colorado 2 and McCutcheon side by side and say that both were correctly decided.
Thank you. Justice Gorsuch?